Well, as Uber grows, so do its challenges. And some of those challenges could end up bringing legal cases. Uber and Lyft facing lawsuits now brought by drivers in cities that could dramatically increase the costs of doing business and potentially change their business models. Kate Rogers reports.
The model that has allowed the sharing economy to flourish could change dramatically as decisions are awaited in two lawsuits filed against tech startups Uber and Lyft in California. At the heart of the cases, which seek class action status, is whether their drivers are independent contractors or employees. The plaintiffs argue they're employees and are seeking reimbursement for things like gasoline and vehicle maintenance. If judges rule in their favor, costs for transportation technology startups Uber and Lyft could increase significantly to include things like health insurance costs, Social Security, unemployment insurance, and wage protections. Uber and Lyft argue they're technology platforms providing services to drivers as well as passengers. In Los Angeles, an Uber driver who asked us to withhold his name says he's spending $80 a week on gasoline, $30 a month on car washes, and $300 a year on maintenance. His reimbursement on those costs alone could near $5,000. He may be an independent contractor, but feels like more of an employee, as he claims Uber has control over the jobs he accepts.
Really, what I feel that I am as an employee, given that Uber controls everything I do, from where I go to how I can look, how I can talk to people. And every job that I take, I'm even forced to take it even if I'll lose money on the contract. Otherwise, I'm fired. So in that way, too, I feel like an employee because I'm not really given a choice as to what my duties are.
But not all drivers are pushing for benefits. Brooklyn-based Lyft driver Robert Henderson says he likes the convenience of being an independent contractor, although admittedly he receives health insurance through his wife. Becoming an employee would change his outlook.
Because I will now feel it's an obligation, and I don't want the obligation feeling. I like the fact that whenever I'm ready to work, I could work.
But attorney Shannon Liss Reardon, representing plaintiffs in both cases, says flexibility and employment status aren't mutually exclusive.
That's a common refrain that, oh, the workers like being their own boss, they like being an independent contractor. But the truth is they're not independent contractors. They're working for these companies, they're following these companies' rules, they're not getting paid proper wages and employee benefits.
Uber and Lyft declined to comment, and while the decisions could be limited to drivers in California, Liz Reardon plans to appeal that, seeking nationwide class action status, which could be a game changer for other sharing economy startups across the country. For Nightly Business Report, I'm Kate Rogers.